Good afternoon, and welcome to the first webinar in a six-part series on sexual harassment and assault in the workplace. I encourage you to check out the section of Civil Rights and Social Justice's website, www.americanbar.org/CSRJ, for news and information and replays of our great programming focused on the impact of our current administration on civil rights and social justice and civil liberties issues. I also invite you to become a section member and work with one of our substantive committees on other great programming and writing opportunities. Before I introduce Sheila Thomas, who is a council member and member of our working group on sexual harassment and assault, I just want to point out 2 or 3 resources on your drop-down buttons that you can see on your webinar platform. The first is a drop-down that says polls, which it will come up so that you will be able to answer poll questions as we go throughout the program, and that will allow us to interact and respond appropriately. The second, there are handouts, a series of 5 handouts that offer resources, today's PowerPoints, and specifically 3 scenarios that we ask you to look at, and we will poll you on whether or not you believe those are descriptions of sexual harassment. And finally, the drop-down that says questions, we will be monitoring the questions throughout the program so that if you have any that you'd like us to speak on during the program, please send them our way through that, and our moderator will ask them to the panel. I now introduce Sheila Y. Thomas, who is our council member and moderator for today's program. Sheila?
Okay. Yeah, good morning. Oh, well, actually, it's good afternoon. I'm in California, but it's good afternoon for, I'm sure, many of you. My name is, as Paula said, my name is Sheila Thomas, and I'm actually the vice chair of the Civil Rights section of Civil Rights and Social Justice section for the American Bar Association. I want to welcome you, the ABA section of Civil Rights and Social Justice, the Commission on Women in the Profession, the Commission on Domestic and Sexual Violence, and the Young Lawyers Division have organized this webinar series to provide an opportunity to hear from experts on different aspects of sexual harassment and assault and the law to contribute to the ongoing movement sparked by Me Too, the hashtag Me Too media reports and resignations and termination of high-profile men accused of sexual harassment and rape. Each of the webinars will be live, and a replay will be available on our website and shared with all registrants. After the 6-part series that runs through July, we hope you will join us at the Civil Rights and Social Justice section's showcase panel at the 2018 ABA annual meeting in Chicago on this subject. Today's program is entitled Sexual Harassment and Assault in the Workplace. What is it? Where does it come from? And what is its scope and impacts? And what is the history of sexual harassment law and response to it? This sets the stage for the conversation that we are proud to offer to our members and non-members alike. In this webinar, we have 2 experts. One of them is law professor Sandra Sperino from the University of Cincinnati School of Law, and Maya Raghu, director of Workplace Equality and senior counsel at the National Women's Law Center. I want to just give you a little bit of a background on our 2 panelists, and then we will begin. Ms. Maya Raghu is director of Workplace Equality and senior counsel, works on women's economic security and employment opportunity, including sexual harassment. She is a graduate of Trinity University and a fellow Georgetown Law Center graduate. Sandra Sperino is Associate Dean of Faculty and Professor of Law at the University of Cincinnati College of Law. She teaches civil procedure, torts, and employment law, including sexual harassment. Her recent scholarship focuses on the intersection of torts and anti-discrimination law. In November of 2017, this is very timely, Professor Sperino co-authored with Suja Thomas an op-ed published in the New York Times titled "Boss Grab Your Breasts, That's Not Legally Harassment." Perfect for this webinar. Today's format will be more of a dialogue. I'll be asking a series of questions, and our panelists will be answering them. We encourage you to ask questions. And as Paula has described on the side, you can ask questions, and please, we ask that you fully participate in the polls as well as the discussion. So let's get started. The first question is, what is sexual harassment? And we will start off with a poll. And there are 3 scenarios, and we would ask that you please let us know. There's a resource on the side which have each of the scenarios. The first scenario is one in which Jane is an assistant to the CEO of a company for 4 years. Over the years, the CEO has complimented Jane on her clothes and jewelry. The CEO recently began sharing with Jane that he and his wife are having marital problems. A couple of weeks ago, the CEO asked Jane out for drinks. They have gone out after work with other staff in the past. However, this time, when Jane accepts the CEO's offer, no one else joins them. The CEO again mentions his marital problems and continuously buys drinks for himself and Jane. Jane begins to feel uncomfortable, but stays until finally she tells him she needs to leave to meet a friend. Is that sexual harassment? Yes or no? It's very interesting to watch. Okay, so the poll results, it's interesting because initially the poll showed that the majority thought that it was sexual harassment, but at the end it's 58% no, 42% yes. The second scenario is one where Diane is a 5th-year associate at a law firm. She works primarily with a litigation partner who is one of the primary rainmakers in the firm. They are recently preparing a case for trial. The litigation team one night goes out for dinner, and then everyone goes their separate ways. A couple of hours later, the partner with whom Diane works comes to her apartment. Although it is late, she allows him into her apartment. He proceeds to touch her and remove her clothing, eventually forcing himself on her. Humiliated, Diane calls in sick the next day. Is that sexual harassment? It's my guess that it wouldn't be a surprise to anyone that 91% said yes, that was sexual harassment, 9% said no. And now moving to the third scenario, and I want to thank Maya for this idea because it's a great idea, it gets people engaged. Jim has a boss who hugs him while looking over his shoulder at his computer screen. He is uncomfortable, but is concerned about what will happen if he expresses his discomfort. He eventually finds another job and leaves. Is this sexual harassment? Looking at the results, 63% say yes, 37% say no. So now I ask the panelists, what is sexual harassment? Maya?
Well, sure, I can start. So I think there's a few different answers to that, which Sandra and I will explore today. So what is sexual harassment? Well, to put it simply, it's a form of sex discrimination that is illegal under Title VII of the Civil Rights Act of 1964. Most of you know that Title VII prohibits employers with 15 or more employees from discriminating on the basis of sex as well as other protected characteristics. But let's take a step back from that. So sexual harassment is unwelcome behavior that happens to you because of your sex. And over the years, sex has been interpreted not only to include sort of gender, but also whether you're pregnant, sexual orientation, and gender identity, at least as interpreted by the EEOC and some federal courts, still an evolving area of the law. But sexual harassment includes a range of behaviors. So it can be something like comments or gestures. It could be demands for sexual favors. It could be unwanted touching, and go all the way to sexual assault. And I know that in the last several months, with sexual harassment sort of in the public eye and a lot of discussion about it, a lot of the initial discussion really focused on sexual assault and rape, which are incredibly serious. And that's not to say that all forms of sexual harassment aren't serious and they aren't wrong, but it's important that we acknowledge and explore sort of the wide range of behaviors, because as we'll get into today, part of the reason that so many people have been silent for so long or have had a hard time coming forward is the way that our culture and the law has tended to minimize some of the things on the left-hand side of this spectrum, even if they were repeated and happened over a long period of time. So in addition to unwelcome sexual advances, hostile verbal or physical conduct, we're all familiar with the idea of quid pro quo sexual harassment, which is when submission to sexual advances or demands for sexual favors are used as the basis for employment decisions. So saying to someone, you know, if you don't have sex with me, you'll lose your job, or you'll get this promotion if you go on this date with me and sleep with me, in that sense. But a lot of sexual harassment also falls into the category of hostile work environment harassment. And that's
Well, there looks like there's a bit of a, yeah, I know there's no audio because I think you can hear me, but I think that Maya's connection has
sufficiently severe or pervasive.
There it goes. Okay. You cut out for a moment, Maya.
Okay, sure. You did as well. Maybe there's a problem with the connection. So I was just talking about what hostile work environment harassment means and what does severe or pervasive really mean under the law. And there's a whole body of law that's developed around that, which essentially has made it really difficult for plaintiffs to prove that they were the targets of sexual harassment. And I said we'll talk about that more later. But stepping back from that, I also want to talk about sexual harassment as a civil rights issue and as a workplace equality issue, because that's an important conversation that needs to happen in light of the larger public conversations that we're having about sexual harassment and sexual assault in the context of the workplace. Sexual harassment is an expression of power. It's not really necessarily about sexual desire. It is used to reinforce cultural norms about appropriate roles, appropriate behavior, and work for men and women, and to exert control over people with less power in the workplace and in society. It could be women, women of color, people with disabilities, LGBTQ people, or immigrants, or young workers. And the sexual or sex-based element of workplace harassment that people experience, including demands for sexual favors or denigrating comments about someone because they're a woman, really enforces and perpetuates sexist and racist power structures in our workplace and in society that value these people less. And so that is the bigger structural and institutional context in which we need to be thinking about sexual harassment and how it is connected to other forms of discrimination, the way workplaces are structured and who has power and who doesn't, because that has a huge impact on people speaking up and whether the different institutional processes and structures that several months, in many cases, they haven't been effective, and we'll explore more today. So okay. I'll leave it at that and turn it over to Sandra.
Yeah, and Sandra, one of the things that I would ask that you also talk about is, like, as the polling showed, people have different, sexual harassment can be in the eye of the beholder. And so I'd ask that you'd also address that as well.
Absolutely. So thanks to everyone for joining us today. I see we have a number of people here from across the country, and that's fantastic. And I think we're having a really important conversation today about sexual harassment. And I want to emphasize that it is a conversation. So we're just in a very exciting time, I think, where we're seeing more what sexual harassment looks like, and I think people are understanding sexual harassment more, and the norms are evolving, and so it's great to see so many people participating. So I want to emphasize a little bit of what Maya said, and also build on her terrific introduction. And so the first thing, I'm glad that Sheila asked this question to start with, because I think it's really important that we define what we mean when we're talking about harassment. And the reason that that's so important is that harassment can take many forms. And one of the things that you'll hear us talking about today is that there is probably a big difference between the legal definition of sexual harassment and what a reasonable person in a workplace would think of as sexual harassment. And I'm not saying that that's good or that that's right, but as we continue our discussion today, we're going to be drawing some distinctions between what's legally recognizable harassment and maybe what a reasonable person might think of as harassment in the workplace. And so I want to start again by just emphasizing the legal definition. So as most of you probably know, Title VII is the federal statute that prohibits employers from discriminating against employees on a number of factors, but the one we're going to focus on today is because of sex. And as Maya already indicated, sex discrimination includes the idea of sexual harassment within the broader parameters of sex discrimination. So when we're talking about sexual harassment, as Maya reiterated, it takes many forms. So it can be sexual in nature, and that's what's actually been getting the most media attention recently. So it can be requests for sexual favors, and it can also be verbal and physical conduct that is of a sexual nature. But I also want to emphasize that it doesn't necessarily have to be so, right? So within the framework of sexual harassment, we also have what we call a hostile working environment. And so we can have a series of comments or conduct that's some may be sexual and some not, or none of it may be sexual in nature. So, for example, if we have a supervisor who repeatedly demeans a woman, this could be sexual harassment. If he says women shouldn't work here, or women should be in the kitchen and not the workplace, those kinds of comments. And if it happens enough over a long enough period of time, that would be sexual harassment, even if it wasn't sexual in nature. And so I just put the hypothetical on the slide for use. So again, if there's a repeated use of demeaning names and demeaning conduct that happens over a long enough period of time, even if it's not sexual, that could be sexual harassment. Now, as Maya also indicated, Title VII, even though it doesn't use the word severe or pervasive, the courts have read these terms into Title VII. And so these words are not in Title VII. They're a judicial gloss that judges have put on the statute. And so later on in the program, I'll walk you through the words of the statute and then sort of how we get to severe and pervasive. But the reason that this is important is that when we're distinguishing between legally cognizable claims and claims that won't merit a remedy at law, we need to figure out what the courts are talking about when they define severe or pervasive. Because if you have a situation that the courts would not define as either severe or pervasive, then what happens to the person does not legally count as sexual harassment. And again, I want to emphasize, this does not mean that the person is not facing what you or I might consider to be sexual harassment, because there's a distinction, I think, between what a typical worker would think of as harassment and how the courts define it. And so if we think about the court's language, the courts frequently say that offhand comments, infrequent teasing, or isolated incidents do not legally count as sexual harassment. And so today we'll be talking about the conduct either has to be severe, so one very terrible incident, or pervasive, so less serious incidents, but more of them over a longer period of time. And so one of the other things I want to emphasize is the harasser can be many different people in the workplace. It can be the victim supervisor, a supervisor in another area, a coworker, or someone who's even not an employee of the employer, such as a frequent client or customer. And even though in this presentation, I think we'll largely focus on sexual harassment against women, remember that men can suffer from sexual harassment as well. And so I just want to keep that in mind as we continue our discussion. So with that introduction, I'll turn it back over to Sheila.
Well, one of the things that I wanted to just kind of discuss where we can, and Maya talked about this a bit, because expanding it beyond what the law would say is sexual harassment, and one of the reasons why I did the poll was to show that there are various forms in which sexual harassment can take place, and people can have very different views about what is and what isn't sexual harassment beyond what the law says. And so I'm wondering, in terms of the next question is about what are the factors that foster a culture of sexual harassment? What are those things that contribute to it? I shared earlier with the panelists that there was an article yesterday about Catherine McKinnon, who was actually is the person who developed the initial legal strategy for in a very well-known book that resulted in the development of sexual harassment law. And one of the things that she talked about, which I think we can talk about today, is this whole thing of a culture of sexual harassment. What are those things that factor into creating environments that can be demeaning to women and others who are harassed?
So Sheila, this is Sandra. I think I'll go first. So I think we could actually spend our entire time together discussing this topic. So I'm just going to focus on a couple of different issues. And the first one is that I think it's a mistake if we think of sexual harassment as different from other kinds of sex discrimination. Now, the courts tend to think of it this way. So they tend to speak in language that says there's a sexual harassment claim and a sex discrimination claim, and the courts tend to use different frameworks in evaluating them. So there is a legal distinction that we see. But I actually think that that division that lawyers have imposed is a little bit problematic, and I'll talk about why in a second. Second, I think the way we settle disputes is a problem, and that's been getting a lot of media attention, and I'll explain a little bit more about that. And then finally, I'm just not sure that the way that we've set up our very complicated litigation-based Title VII remedy regime, I'm just not sure that that regime is conducive to even resolving individual problems very efficiently. And then second, I think it causes us to ignore some structural problems. So let me return to the first idea. So again, in the law, we see this distinction where sexual harassment has developed as a different type of discrimination. And I'm using that word just very loosely as to describe how the courts explain this. And then the courts tend to separate that from what they call sex discrimination, which are cases where there's a failure to hire or a failure to promote or a termination that's based on someone's sex. And so as lawyers, I think we're very used to thinking about sex discrimination as different than sexual harassment. But I think that one of the things that we're seeing from #MeToo and the issues that are happening in Hollywood is that there's actually a powerful connection between what we would call sex discrimination and sexual harassment. So if you think about some of the prominent Hollywood examples, there's sexual harassment and including sexual assault that is going on. But there's also a powerful history of sex discrimination. So we have pay inequality issues that are coming to the forefront, as we saw at the Oscars. And there's also sort of a glass ceiling or sex segregation that's happening with fewer women being directors and having financing roles in Hollywood. And so I'd like to at least ask people to think about whether those two are connected. And I think that there's a strong case that they are. So we're obviously not going to sort of resolve the dichotomy in the law in our webinar today, but for those of you who litigate these cases, or if there are any judges on the line, I'd ask you to think about maybe describing your cases in ways that show that sexual harassment and sex discrimination are actually more closely aligned than the law might have us think. So the second thing I want to talk about is the way that we settle our disputes. And I think that that's a problem. And here I'm going to talk a little bit about defense attorneys, and I was one. That's what I did early in my legal career. And so the way that defense attorneys are trained, when they settle cases, they're taught that requiring confidentiality provision is the best for their client. And when we think about plaintiff's attorneys, they are usually representing one client or a small set of clients. And so very understandably, the relief that they demand is often individual relief and not relief that goes beyond the individual. And so when we lack transparency and we also lack sort of attention to structural problems, we're really creating a process that doesn't require anyone to be introspective about what's happening once this case ends. And so I think that the way that lawyers think about settling disputes is actually contributing to some of the sexual harassment that's happening. In other words, our efforts to combat sexual harassment have not been as effective as they could have been because, again, there's a lack of transparency about what's occurring in workplaces. And there's also a push towards individual remedies rather than a look at structurally what's happening. And so turning to the last topic, so I'm often asked, just informally by people, this has happened to me. Should I report it? And what would the process look like if I did report it? And so the story that you tell people doesn't make them want to report sexual harassment. And the empirical evidence actually supports that very few people who suffer from sexual harassment in the workplace actually report it. And the research shows that the main reason that people don't report sexual harassment is that they're worried about retaliation. But I also want to think about how the process that we impose also may contribute to an underreporting. So if someone came to me and said, I'm facing conduct in the workplace that I think is sexual harassment, what should I do? For most individuals or victims, if they want to preserve their claim, for many of them, they're required to first report to the employer. And ideally, and in many cases, the employer will respond appropriately. And the best way to resolve a case is to resolve it at that level, right? As soon as the problem is happening, we have an instant report and then the problem is fixed. Unfortunately, though, if that does not remedy the problem, or if there's retaliation, the person who's facing discrimination really has a long road ahead of them. So most of you who are on this call know that under Title VII, plaintiffs are required to first exhaust administrative remedies with the Equal Employment Opportunity Commission, the EEOC, or a corollary state agency, and then to go through that process. And if someone fails to do that, then their claim is gone forever. Now, if that process fails to resolve the issue, then you're telling someone that they're looking at filing a complaint in court. And under the best of circumstances, that case would be resolved, in several months if we had a settlement, a year to 3 years if we got to trial. You would be telling the victim of sexual harassment that they are going to be subject to a deposition, that they are likely going to be subjected to a medical exam if they're going to request emotional distress damages. You're going to tell them that it's unlikely that their case would ever get to trial, either because the case would settle or because in a large number of these cases, the judge will grant judgment in the employer's favor. And that even if you got to trial, the chances of winning are about 50-50 or 60-40, depending on which research you look at. And even if you win at trial, there's a big chance that either on post-judgment motions or on appeal, that the verdict will either be nullified or reduced. And so when you sort of play out that process for those who are victims of sexual harassment, it's very daunting, and it becomes a process that doesn't encourage people to report. And so I'll stop there and I'll switch over to Maya.
Thanks. So Sandra outlined some of the legal institutional barriers. What I wanted to do is sort of complement that and talk about what are the institutional and structural barriers within workplaces that help foster a culture of harassment. And one of them, so the National Women's Law Center is the home of the Time's Up Legal Defense Fund. I'm sure many of you have heard about Time's Up. Since January 1st, we've received over 2,000 requests for assistance from people all over the country across a range of industries. And in reviewing those requests for assistance and the stories people are coming to us with, it really confirms a lot of what we had known before, which is that this is an incredibly pervasive problem. It occurs in any industry. Anyone can be a harasser, anyone can be a victim, but it tends to occur in certain types of industries or in certain types of workplaces. So we're definitely seeing patterns, and I will go over some of those today. So any work to be more pervasive. And again, that goes back to what I said in the beginning, sexual harassment expression of power, and it is sort of relying on and using existing imbalances in the workplace where workers have few rights, or they don't know the rights that they have, and supervisors and managers and the leadership are really using fear to keep people from coming forward and reporting any kind of workplace violation like health and safety, let alone discrimination and harassment. And that's, again, why discrimination and harassment don't happen in isolation. So what we're seeing is many people who are coming to us to report sexual harassment are also, not surprisingly, experiencing pay discrimination, or women of color are experiencing race discrimination and sexual harassment together, or people with disabilities, because, again, they thrive on that sort of imbalance of power. Another factor that we see is sometimes when people are working in isolation within workplaces, right? So you see this in the hotel industry where the women, frequently women, who clean hotel rooms are often working by themselves for long periods of times on floors, in hallways, or in rooms, and they enter a room and it's just them and the guest. And so anything can happen, and frequently does, where they'll be sexually harassed, guests will request sexual favors, or they'll be physically attacked by the guest and there's no one around to help them. Or for women and men who are working in the fields, they are frequently working by themselves in a row with no one else around, an isolated part of the farm, which again helps breed and makes them susceptible and vulnerable to sexual harassment. We also see this in homogenous workplaces where there are one or two women, or there are people who are sort of non-conforming to the culture of the workplace. So we know that there are very few women who work in the trades as compared to their share of the workforce. And so it's not surprising that they experience a significant amount of gender-based hostility and harassment and discrimination, because generally they're only one of a handful of women on a construction work site, or one of a few electricians in a union. And although there's been significant progress within unions and on work sites to addressing harassment and discrimination, that creates a significant barrier to women's entry into those jobs and to their ability to stay in those jobs. You know, one of the things about sexual harassment is that it leaves so many women in particular to leave their job and to leave a field entirely. Frequently, you know, after they've devoted years of study and have years of experience in that field, they leave it because the harassment is so bad. Another sort of risk factor for harassment, a culture of harassment, is where you have a lot of what we would think of as vulnerable workers. So young workers, it's their first job, one of their early jobs, they may not know their rights, they may be afraid to speak up or don't know that they can speak up or who they can go to for help. Or you have a lot of immigrant workers who, again, may not know where their rights are vulnerable because of their immigration status, which is often used against them for threats and intimidation. Or if there's language barriers, so even if they know their rights, there's issues with communication. This is also a huge issue in any service industry where workers are relying on tips or customer satisfaction in order to keep their job. So that creates a different type of power dynamic, which often leads many individuals to feel like they have to put up with harassment in order to keep their job. And the message from the top is that, you know, don't complain about if customers are harassing you. There's nothing we can do about it. You just need to put up with it, smile, you know, be pretty, and then you'll get your tips. Obviously, there's a huge issue in the restaurant industry and in the retail industry as well. And finally, I want to go back to something that Sandra had talked about, which was this issue of secrecy and transparency. There's been a lot of discussion in the last several months about the ways in which employer-imposed secrecy clauses in employment agreements and settlement agreements have really helped veil and hide the true extent of sexual harassment within a workplace, within a company, within an industry as a whole. And in particular, in the context of employment agreements, we're talking about mandatory arbitration agreements, non-disparagement clauses, and non-disclosure clauses. And those have really operated to prevent workers from exercising rights that they actually already have under the law, or to lead them to believe that they don't have those rights even when they do. For example, a non-disparagement clause that prevents someone from reporting something that they see to an enforcement agency, or mandatory arbitration agreements, which mean that sex discrimination and sexual harassment claims are resolved or sort of litigated and resolved in private forums, and the results are kept secret. So other workers often have no idea that something else is going on. And it really helps isolate workers in a workplace because they feel like they're the only ones, which makes them reluctant to come forward, which again helps hide harassment.
You're okay. All right. So, and now that we've discussed what some of the factors are, the cultural factors, some of the legal factors, then the question is that, and I think that you've already kind of discussed this already. We were going to talk about some of the obstacles, but it seems to me that one of the questions that we might want to talk about is both you and Sandra, both Maya and Sandra have talked about some of the legal aspects, but we wanted to step back to kind of talk about the legal history that has led to this, which has also been, so often the law follows the need. So, for example, we're seeing that right now that the Me Too movement is leading to calls for a change in sexual harassment. So I just wanted to just take a step back for a moment just to talk about the legal history addressing sexual harassment and its relationship to some of the cultural issues that you raised.
Sure, I'm actually going to turn this over to Sandra because I think she was going to go first in this section, and then I can go after her.
All right, great, thank you. So this is going to be a little bit of a longer segment because I want to take you through first some modern examples and then maybe talk about the Supreme Court case law and how we got there. So one of the things I want to emphasize is that our case law does not always define sexual harassment in the same way that reasonable people would. And so I want to talk a little bit about the legal standard and then give you some examples of what I mean. So as Maya and I have both been discussing, the courts require a person to prove that harassment is severe or pervasive. And again, these words are not in Title VII. And so if you actually look at the language of Title VII, the main provisions have two subsections. The first subsection prohibits discriminatory conduct that affects the terms, conditions, or privileges of employment. And so those are the words that Title VII uses. Or if you go to the second subsection, it makes it illegal to have conduct that deprives or tends to deprive a person of work opportunities or otherwise adversely affects her status as an employee. And so what we see is a jurisprudence that the courts developed that is really separated from the actual terminology or words of Title VII. And so one of the things I've been trying to encourage litigants to do is that if it works for your client, you may want to direct courts back to the actual language of Title VII. And so the words terms, conditions, or privileges actually have a rich history in both labor law and in construing arbitration contracts. And they have a very sort of wide meaning if you look at that underlying case law. And also the second provision of Title VII, where something deprives or tends to deprive someone of an opportunity or otherwise adversely affects her status as an employee. I think that's some really rich language that the courts could further develop in thinking about sexual harassment. So looking at the current legal landscape, if we think of the terms severe or pervasive, what we see is kind of a spectrum of conduct. And on one end, we're going to see conduct that every single court is going to say is severe or pervasive. So, for example, if there's a person who's raped by a supervisor at work, this is going to count as severe conduct under Title VII. And almost every judge who sees that scenario is going to say that that violates Title VII. Or if you have a supervisor who demeans a woman with sexist conduct and language every day for several months, that would be considered to be pervasive under the current case law. On the other end of the spectrum is conduct that's never going to count as sexual harassment. So if one time your supervisor calls you into his office and says, even in a very creepy way, I like the way your blouse fits you, or you really fill out your blouse, or something like that. If it only happens once and nothing else happens, no court is going to call that sexual harassment.
But
Now,
is that sexual harassment?
Well, that's a different question, right?
Right, yeah, because I mean, that was one of the things that we wanted to talk about, was that even if the courts don't find it to be sexual harassment, is that sexual harassment?
Well, if I'm representing an employer, I would want the employer to take action and remedy that conduct, because my fear would be that things would get worse, right? So my hope is that sort of this legal definition is not completely guiding employers. This litigation-based definition is not what's guiding employers in taking appropriate action.
Right.
So in the middle, it's where things get a little tricky. And so whether your case is going to make it past summary judgment depends largely on the judge that's viewing the facts and the circuit where the person is litigating. So last year, Professor Suja Thomas from the University of Illinois and I wrote a book, and the book is called Unequal: How America's Courts Undermine Discrimination Law. And so in that book, we talk about the various ways that courts have really strayed from the language of Title VII and created these doctrines that don't fully protect workers. And so in one of our chapters, we look at sexual harassment. And so rather than just talk about the legal standard, we thought it would be more interesting for lawyers and non-lawyers if the book told the story of real cases. And so what we did was we mined thousands of cases, and we looked at the evidence that the plaintiffs brought in these cases as described by the court. So we did not change the facts of the case at all. We just looked at the facts as stated by the court, usually in summary judgment motions or appeals from dismissal of summary judgment motions. And so, of course, at the summary judgment stage, some of the facts are contested, but what we found was quite surprising. And so what I want to do is just walk you through some of the cases, and then I wish I could get your live reaction, but I'll just have to assume that you're thinking about this, and I would love to see what you think about whether this is sexual harassment. So again, these are all real cases. And so there's one case where the allegations were that a manager asked a female subordinate out on dates multiple times. He called her dumb blonde. He put his hand on her shoulder several times, placed I love you signs in her work area, and attempted to kiss her in a bar, and twice attempted to kiss her in the office. And all of these efforts were resisted by the employee. And so the question is, at the summary judgment stage, should the judge let this case go to trial, or are there enough facts here where a reasonable jury could, right, if they believe these facts, find sexual harassment? And so in this case, the court dismissed the case at summary judgment, finding that this set of facts was not legally cognizable, why the conduct wasn't severe or pervasive, or in other words, it wasn't serious enough to deserve a remedy under federal law. And so in the book, we actually have tons of examples, but I'll give you one of a male construction worker. So this is male on male sexual harassment. His supervisor made many lewd comments using the word pipe in place of sort of penis. So he said, do you want to feel my pipe? He asked him that several times. He told them that he was a young strapping man with a nice, and I'll change the words a little bit, but he told him that he was going to sexually assault him on numerous occasions. He blew the plaintiff kisses. He told the plaintiff that he wanted to lick him. When the plaintiff complained, the supervisor told him, and this is a quote, there was nothing he could do about it. He talked about the plaintiff's genitals, and this happened over a 10-day period. And when the worker brought a claim for sexual harassment, the court dismissed the claim, finding that the facts were not pervasive enough because they only happened over a 10-day period. And so again, I'll just talk about one more case. So a supervisor told a worker that the only reason she was there was because, quote, we needed a skirt in the office. He asked her to go to a hotel room and spend the night with him. He asked for a sexual favor. He constantly referred to her as babe, unzipped his pants and moved the zipper up and down in front of her, and referred to women generally using words like slut and tramp. And again, this is a set of facts where the court dismissed the case and found that there is no sexual harassment. So I think that you can find from these examples that there's a huge disconnect between what a typical person might think of as sexual harassment and how the courts define it. Now, I want to just talk briefly about the three main Supreme Court cases in this area. So we start with Meritor Savings Bank versus Benson, which is the 1986 case, and then Harris and Breeden. And so one thing that you can tell just from this line of cases and their dates is that the Supreme Court has not addressed the substantive standard for sexual harassment in a really long time. And so most of the case law that we're seeing was developed by the appellate courts with fairly little guidance from the Supreme Court. And I often say that the Supreme Court is like the bad parent of a teenager, right? It gives these very ambiguous instructions and then sort of lets the teenager, go on his or her own and just sees what happens. And so that's what's been occurring with our sexual harassment jurisprudence. We really haven't had the Supreme Court jumping in very often. And even the cases that we do have provide only the vaguest outline of what the claim would look like. So we start with Meritor. Now, the question in Meritor was the basic one, was sexual harassment even cognizable as a claim? And so there was some confusion in the courts. If you look at the early cases decided under Title VII, the earliest cases tended to be cases that challenged patterns or practices by the employers themselves. So for example, we might have racially segregated hiring or sex segregated jobs by company policy. But in the 1970s, we started to see some cases that looked a little bit different. And those cases are now what we would call either sexual harassment or hostile environment. And the lower courts really disagreed on what to do with these cases. So some of the early courts said, look, especially if this is sexual in nature, this is just private conduct by the employee. And because the employer is the only entity that's held liable under Title VII, then we really can't hold the employer liable for this private conduct. On the other hand, you saw some courts recognizing, especially in cases with supervisors, that the supervisor was placed in a trusting role by the employer and thus had more power to engage in the harassment. And so again, we had about a decade or so when it wasn't clear whether sexual harassment was a claim or not. And so Meritor is a claim. The allegations in Meritor are very serious. So a woman alleged that her supervisor repeatedly raped and sexually assaulted her, sometimes at the workplace. The supervisor denied the allegations. And so the court, given that set of facts, recognized sexual harassment as a possible claim, and then started using the words severe or pervasive to define it. But in Meritor, we don't really get too much meat about the substantive standard because it's really just the first case that recognizes the cause of action and then gives us a very general framework to start thinking about analyzing the claims. And so we jump forward to Harris versus Forklift Systems. And in that case, the court gives us a little bit more of the analytical structure, but it's still not fully complete. And so just quoting from Harris, the court says that whether something is sexual harassment or not is not a mathematically precise test. The court says that we're talking about hostile or abusive conduct, and that we have to look at all of the circumstances when we're looking at whether something's hostile or abusive. And then the Supreme Court gives a list of factors that a court might and is not required to consider, including the frequency of the conduct, its severity, whether it's physically threatening or humiliating, or what the court calls a mere offensive utterance, and whether it unreasonably interferes with an employee's work performance. In Harris, the court also held that the harassment doesn't have to be psychologically crippling in order to be cognizable. In other words, you don't have to have a nervous breakdown or some severe emotional distress that results in order to state a claim. Now, the third case, the Breeden case, is probably the weirdest case in the employment discrimination canon. The facts are strange, and it's also a case that I just don't see it applying in many other scenarios. So in that case, we had a woman and two men who were sitting in a room, and they were evaluating job applicants. And one of the men in the room was the woman's supervisor. And so as they were looking at the applicant's files, the male supervisor read aloud a sexually explicit remark that one of the applicants had made to a coworker. And he looked at the other man and stated, quote, "I don't know what that means." And then the other man replied, "Well, I'll tell you later." And then both of the men chuckled. And so Ms. Breeden complained to HR about this interaction and then alleged that she faced retaliation after complaining. And so the court held that there was no retaliation because a reasonable woman would not believe that the interaction constituted sexual harassment because it was an isolated incident. And because a reasonable woman wouldn't think it was sexual harassment, her complaint was not protected activity for purposes of retaliation law. So I think the facts of Breeden are a little weird, but also most plaintiffs who are bringing sexual harassment complaints are complaining of conduct that either has happened repeatedly or is more severe. So I'm not sure how helpful Breeden is in the kind of pantheon of Supreme Court cases. But let me stop there and either turn it back to Maya or Paula.
Well, actually,
Sandra.
Can I say something right quick? I actually think that one of the things that that we should probably do is go before Vinson to the fact that this was a legal theory that was developed by Catherine McKinnon, which was much broader, and the argument was much broader than what the Supreme Court said. I think it's important to point that out because the idea was originally was that the theory was to be used for a much broader structural problem and not just individual workplace issues. And then over time, the court has narrowed it in a number of ways where an ordinary, the whole concept of what a reasonable person is, which is the standard in California, as well as other places, is such that it would also, what is a reasonable woman? And how do you determine that? And how do judges determine that? Go ahead, Maya.
So I'll just say, I actually think, the issue sort of started with Meritor and Vinson. It was important, obviously, for recognizing that sexual assault is a form of sexual harassment and it's cognizable under the law. Because previously people just considered that to be an issue of a personal relationship and it wasn't a legal civil rights issue. The problem, though, is that it set such a high standard for such severe conduct, sexual assault, that anything else that doesn't rise to that level has proven, to be very difficult for courts to accept as being severe or pervasive, unless, sometimes one incident is enough, but it's very, very rare under the case law now. And I wanted to go back and just add a discussion about a couple of other significant Supreme Court cases that have really shown the way the law has evolved and is still evolving and still present barriers to individuals who are trying to challenge sexual harassment in the workplace. And it has a lot to do with the court's conception of a traditional employment relationship. A lot of sexual harassment law is predicated on this agency theory, right? And that's why employers are held vicariously liable for supervisor harassment because of that agency relationship. And it's why under certain circumstances, employers can be held liable for the acts of coworkers and third parties like customers. It's just that it very rarely happens. So that supervisor liability and that structure, the last case that really had a huge impact on that was the Farragher-Ellis pair back in 1998, which is when we started to see this explosion of employers creating sexual harassment trainings and policies, because those cases said that employers could have a defense to liability if the company took care to prevent and correct harassment by having policies and training, and the individual unreasonably failed to take advantage of those procedures offered by the company to address harassment. And that's why, as Sandra mentioned earlier, it's so important for individuals to go through make a complaint through their internal company procedures first. Otherwise, employers could have a defense when this becomes a lawsuit. The other big issue related to supervisor harassment had to do with the Vance v. Ball State case in 2013. And that addresses the question of who is a supervisor under the law sufficient to trigger that liability for employers. So in Vance v. Ball State, the court examined what sort of duties makes a supervisor essentially. Is it authority to hire, to fire, to demote, to cut pay, to set schedules? And in that case, the court said a supervisor is very narrowly defined. It is only someone with the authority to hire or fire you or make decisions about your pay, but not any of the other things, any of the other duties that many supervisors and managers have that give them an extreme amount of day-to-day control over the lives of workers. This is particularly an issue for workers in low-wage jobs, right, where there are a lot of sort of mid-level managers who can set their daily schedules, decide when people take breaks, decide when they can go on leave, decide who gets the best schedule, decides what the duties are. And because of that decision, it has made it much, much harder for workers, particularly in those sort of low-wage service jobs, to hold employers liable for sexual harassment by supervisors. Since that decision, we've seen a whole slew of cases in the lower courts where managers were sexually harassing their subordinates. They had the power to make their schedules and to decide, when they would get assigned to particular shifts and the pay assigned with that, but they could not hire or fire them, and that's where the courts are drawing the line, and has left a lot of workers without protections because it's much more difficult to meet that harder negligence standard because those supervisors are considered co-workers under the decision instead of supervisors. So in addition to customer harassment, that has proven to be a huge problem for a lot of workers.
Now, I wanted to see, for those who are on the webinar, are there any questions from those who are participating? Here's one I see that says, I'm trying to see the whole thing. Are there contexts? There's a question here that says, I can't go into my workplace and punch my coworker or attempt to abuse my coworker. Are there contexts in which sexual harassment, assault, battery is treated like bullying?
This is Sandra. I can jump in. Obviously, there are other legal frames that we can use other than Title VII to think about some of these problems. And so certainly in instances of assault, the criminal justice system might be an avenue. Another avenue might be tort law. And so if you think about battery or assault, or in some cases, intentional infliction of emotional distress or negligent infliction of emotional distress can be claims. Now, what I've seen, I'm fortunate enough to teach in the areas of torts and employment law, is that when you see a workplace tort, most state courts are actually reluctant to sort of have the tort law apply in its fullest extent, especially when you're thinking about IIED or negligent infliction of emotional distress. And so there are cases that in other contexts outside of work that would meet the standards for the underlying cause of action, where courts are really reluctant to declare a cause of action when the conduct happens in the workplace. Now, in researching our book, Suja and I also strangely found cases where the court allowed the state law assault or battery claim to proceed while also declaring that the conduct was not severe or pervasive enough to be sexual harassment, which I just found very strange. But there are cases letting the tort law claims go to jury, but not the sexual harassment claim.
I'll just add that, you know, the federal courts in particular have been pretty clear that they're reluctant to sort of second guess any employer decisions that are made about behavior that may fall into a so-called gray area, whether or not it actually is a gray area. And so a lot of those cases, it's sort of hard to proceed under federal law. And then I would also just add that a lot of states are passing statutes to address bullying behavior. So that might capture some of the behavior that you're talking about. And what we've seen, though, is, you know, that's becoming an issue because most employers' harassment and discrimination trainings are so compliance focused that they're not actually addressing sort of the precursor behavior to harassment, so sort of incivility, disrespectful behavior, aggressive behavior, bullying, that I think someone at the EEOC always refers to as incivility as the gateway drug to harassment. So part of the reason that you're seeing state laws develop to address that behavior is because it hasn't been effectively addressed by employers who are just sort of talking about what is illegal under the law, but not all the behavior that they could still say is unacceptable in a workplace context that doesn't necessarily reach the threshold of harassment under the law.
Right. So here's another question is, and I think that there was a little bit of a typo, is why are judges inclined to rule in favor of employers? Is it because the employer has deep pockets and can afford better lawyers, or is it indicative of societal cultural norms?
So this is Sandra. I can take this question. So, you know, in our book, we actually thought about this quite a lot. And so I think some scholars would tell you that there is a political bias. But when we dug down into the research, we actually didn't find that compelling for most of the cases. And that's because most cases are decided by trial court judges. And so we just couldn't see sort of the political bias narrative playing out. Now, Now, certainly at the Supreme Court level, you do see justices appointed by Republicans often favoring the employer sort of friendly legal standard. Although even there, if you look at the recent Supreme Court cases, I think the latest study I saw said that about 60% of the Supreme Court cases are rule in favor of the plaintiffs. Now, that may be also because there are some very conservative appellate level courts. So I actually think that one of the problems that's going on in the sexual harassment context is there's some very bad appellate case law that was handed down in the early 1990s. And so I started our discussion today saying that we're having an evolving conversation about what constitutes sexual harassment, but that's a problem when you have precedent, right? And so if you have a case that was decided, like one of the cases that I discussed the facts of earlier in the 1990s, and then you have a district court judge looking at that case and saying, well, look, in that case, he asked her out on multiple dates and he tried to kiss her multiple times and he touched her several times. And wow, my appellate court said that wasn't sexual harassment. I feel constrained by precedent now to rule in favor of the employer. And so at the trial court level, it's really hard to figure out whether the trial court judge personally believes that's the right legal outcome or whether they feel bound by these older cases. And so I actually tend to think that precedent's playing a big role here.
I'll just add two things. One is that it's not a political bias question necessarily, but it has to do with thinking about who judges are and the diversity or lack thereof in federal and state court benches and the life experiences that judges bring to the job, which, you know, if you're, let's say, an older white man who sort of has had, you know, you went to a well-regarded law school, you come from a wealthy family, then you may not necessarily be aware of or going to be able to relate or understand the experiences of someone that's coming to you and it's the sexual harassment claim from a very, very different context. And, you know, a lot of judges have issues believing individuals, especially when they didn't complain about the harassment immediately and let it go on for some time because they sort of felt coerced into having to put up with it for one reason or another. I think it also has to do with the way that our cultural norms have minimized and normalized a lot of different forms of what might be considered sexual harassment, but sort of culturally and under the law aren't. So, you know, Sandra was discussing situations and cases which most of us would probably consider sexual harassment, so being groped and sort of repeated requests for sexual favors or constant denigrating comments. But for a lot of judges just don't rise to the level of sexual harassment because they're not severe or pervasive. But part of that is because people have started to think over the years, particularly in certain industries, well, that's just how it is. If you're, you know, you work in a restaurant, you just sort of brush off the comments of customers who comment on your experience, on your appearance, or pass you their number and ask you out on dates. And this is what we've heard from people who work in the restaurant industry, especially, that behavior is normalized and accepted in the industry. So people aren't even coming forward to complain, which ultimately hurts them when they try to bring a lawsuit later. The other thing I'll also say is that, you know, state anti-discrimination laws often offer more protection than Title VII in a variety of ways. But what we frequently see is that state court judges are sort of reading federal standards into the state law when they interpret and apply them, which is creating a problem and sort of artificially narrowing state law.
Well, I think that the issue that you raise about the diversity of the bench is a significant one, and because the cases are so fact intensive, and I recognize the value of legal precedent, but sometimes judges can see the same set of facts and come to a different result. So one of the questions would be is that if you have a different kind of experience. So, for example, Judge Kozinski, just raising this as a question, is Judge Kozinski, how would he handle a sexual harassment case versus, a judge who has a different life experience? Because if your own individual conduct is reflected in that might not be sexual harassment in your own mind, but it may be the experience of sexual harassment for someone who's actually experiencing it. I mean, I think that point that you made is a good one. There's another question here that says, following up on this question that you had about supervisor. The question is there less regulation for employee misconduct?
Well, in the sense that coworker customer harassment, there is a different liability standard. It's sort of narrower and harder to show. It's basically if the employer knew or should have known what was going on and taken steps to address it, but didn't. So that's harder. So I'm not sure if that's sort of what you were getting at with that question.
Yeah, well, that's the question that they were asking. The answer is that employee to employee is much more difficult, except in some states. So, for example, in the state of California, you can have individual liability.
Right. So that's a point I wanted to bring up. Under federal law, there is no individual liability for harassment, right? It is only to the employer. But some states, like California, have made it possible for an employee to sue another employee individually because of sexual harassment. I'll also add that in cases like of sexual assault, of course, you can always bring like a tort claim against an individual. Right.
So one of the issues, because we're actually getting close to the end time, is that Maya, you had earlier mentioned the issues of intersectionality with race, disability. Can you talk a little bit more about that and how it plays out in the cultural issues that we've discussed today, and how sexual harassment may impact different people based on what those intersections might be?
Sure. I think, what we're seeing, again, going back to the issue of sexual harassment and harassment as a form of power, when individuals who are employees are members of groups with different protected characteristics, often you can't view membership in those groups in isolation, right? And the vulnerabilities created by being in those groups in isolation. And obviously there's that great article by Kimberly Crenshaw years ago, which really brought this idea of intersectionality to the fore, which is that if you're a woman and a woman of color, then the discrimination you experience it together and it's compounded. So you can't look at them in isolation and ask people to say, I'm going to bring a claim based on sexual harassment because I'm identifying as a woman when I bring this claim, as opposed to a Black woman who is also experiencing racialized sexual harassment, for example. And it's the same for people, one thing that hasn't been part, I think, of this bigger national conversation and reckoning we've been having with sexual harassment is the way that it impacts people with disabilities, for example, and the additional barriers they face in coming forward. Because people just sort of aren't thinking about their needs or the resources they need to address harassment, or the way people aren't thinking about or talking about sexual harassment of women. But as we've mentioned, men can harass men, women can harass women, and LGBTQ individuals experience significant levels of workplace sexual harassment that, again, really hasn't been part of this conversation. Part of that is there's a lack of research. And so one of the, many reforms that Law Center and other groups are working on is figuring out how can we do better at documenting the problem so that we have evidence when we want to go back and show that there need to be legislative or legal solutions to address these problems.
Sandra, do you have anything you want to add?
Mindful of time.
Yes, right.
I just want to reiterate, read Kimberly Crenshaw. So if anyone is interested in intersectionality, as Maya mentioned, Professor Crenshaw coined the term intersectionality, and it just refers to that really important concept that constructions of race and sex can combine to cause different kinds of oppression for people of color. And so to just think about, when we're thinking about sexual harassment, not to just focus on white women, for example, but to make sure that when we're remedying discrimination, we're doing it across different categories.
So I'll just add, there are a lot of efforts at the federal level and across states right now to introduce legislation to strengthen existing anti-discrimination protections. And a lot of that, we're sort of involved in all those efforts, and I'm happy to answer questions offline. But one of the big issues we see is policymakers are focused on addressing sexual harassment because that's what's in the news. And, the caution that we have for them is solutions that are focusing only on sexual harassment ignore the sort of intersectional discrimination that many people experience. And creating a right or remedy that sort of only privileges sexual harassment will result in a lot of unfortunate unintended consequences in the law and sort of force people to choose the identity they want to bring to a claim, even if sexual harassment claim is much weaker than their racial harassment claim, for example.
So I want to ask once again, I've asked some questions that I've seen. Are there any other questions from those who are, any of the attendees with the webinar, questions to ask the panelists? I guess not. So do you have, the two of you, do you have any closing remarks you'd like to make before we end?
Sure. This is Sandra. I'd actually like to talk about solutions or ways forward. So I'd like to end on a positive note if we can.
Okay.
So one of the things that's been really heartening to me about Me Too is that I think we're having, or what I hope is, a moment of cultural change. And so I think it's important, especially if there's any non-lawyers on the call, to recognize that it's not judges and lawyers who are always leading legal change, right? So judges and lawyers are part of the culture, and every major civil rights advance that's been made has been this very intricate dance between culture change and legal change. And so I think it's important to recognize that the cultural conversation might itself be pushing forward legal change. And so I think this is a great time for HR departments to think about how they police sexual harassment, and whether HR departments are instructed to have a culture of compliance, or whether they want to have a culture of no tolerance for sexual harassment. And I think that you might end up with a different HR response if you focus on prevention rather than on just compliance. And so I want to give maybe a couple of options for folks who are thinking about the legal change. So if we have any judges on the call, or any folks who litigate in front of judges, I hope that you might think about the severe or pervasive standard, whether that needs to change, whether judges can and should change that, and whether the judges, especially at the appellate courts, should repudiate some of those early cases that have created these problematic standards. And then as you're thinking about change at either the state or federal legislative level, think about a couple of possible changes. One would be an amendment to Title VII that's very similar to what happened with the Americans with Disabilities Act. So in 2008, Congress amended the ADA, and one of the amendments essentially said, hey, courts, read this statute liberally when you interpret it. And so Title VII could use an interpretive clause like that, or Congress might consider, or state legislators might consider amending the severe or pervasive standard. So I do think there are some realistic, positive steps forward, and I just wanted to leave people with some of those ideas.
Maya, do you have anything you want to add? Oh, she disappeared. Oh my goodness. All right. Well, if there are no other questions.
Yeah.
Oh
no. Hello?
Hello? Yeah.
Can you hear me and see me now?
Yeah, yes.
Okay, great. Okay, great. So I had a couple of legislative and policy suggestions, and then also wanted to talk briefly about culture change. So with regard to legislative and policy change, in addition to what Sandra mentioned, I just wanted to give you sort of a brief overview of what is sort of hot in the states right now and what legislators in Congress and in the states are focused on. So there's a lot of interest in.
Maya, we only have like about 5 minutes, so just keep that in mind, because I actually need a couple minutes before we end.
So they're interested in extending protections to more employees. So lowering employer size thresholds so that folks like domestic workers are covered, and covering independent contractors. There's a lot of interest in addressing transparency and secrecy in employment agreements and settlement agreements. So proposals to ban the use of mandatory arbitration agreements, non-disparagement and non-disclosure clauses in pre-employment contracts, as well as in settlement agreements, not outright bans necessarily, but trying to balance the equities between privacy and transparency. And then efforts to have employers report out on the number of settlements and judgments relating to harassment that they have dealt with, or particularly reporting or requiring court approval of settlements with NDAs in them. So just wanted people to be aware of that. The other thing with regard to culture change, as I said, is a couple of really important things. There's institutional level change and then structural change, and then there's individual change. And I wanted to highlight two things. One is the importance of bystander intervention. So empowering and letting people who are observing what's happening, who are coworkers, colleagues, empowering them to step up and intervene and interrupt harassment and discrimination when they see it happening is really, really critical for culture change. The other thing is the importance of men as allies in this. So men talking to other men about their behavior, to calling out other men, and using their privilege and power to change that dynamic and change the cultural norms that keeps men who want to do the right thing from speaking up about sexual harassment and assault.
Thank you. Thank you. So I want to once again thank Sandra Sperino and Maya Raghu for what I think was an excellent webinar, and I want to remind those who are on the in the webinar that invite you to join us once again on Thursday, April the 5th, for another webinar titled "Barriers to Combating Sexual Harassment in and Out of Court and Legislative Responses in the #MeToo Movement." The moderator for that will be Kristen Gallas, who is a division director in the ABA Civil Rights and Social Justice section. And the speakers will be Deborah S. Katz, founding partner of Katz, Marshall, and Banks, and Jessica Stender, who's senior counsel at Equal Rights Advocates. Thank you for joining us, and have a wonderful day.